Well, I am Amy Herrick. So one of my goals in life is to help you to leverage your assets a little bit better and also to retain more wealth. So we're going to be working on things that are for the individual or for the small business owner, because what I find is a lot of business owners do not integrate some of the personal with the business. So today we're going to talk about account titling, because this is something that I see runs into being an issue. You don't notice it until a little later. So when we understanding the impact of account titling and account ownership differences, there's a lot of different things that fall into this. And I find that most people don't really understand the impact of the titling and what the ripple effects can be over time. Always got to give that wonderful disclosure. It keeps all the attorneys happy. You know, information is very general. And this is for a wide audience. For your own situation, you may want to consult your financial advisors. If you don't have someone along those lines, if I can be of help, then reach out to me. Now, I put this up because I want to start out with, can someone describe eggshell to me? And when I'm in some of the rooms that I have a lot of people, you know, we'll have hands pop up, but it'll be something like, well, what is an eggshell? And first I get the blank looks of, well, what do you mean, what is an eggshell? Well, it's that thing that's around the outside of an egg. And then when you break it, you know, the egg falls out. What's an eggshell? Well, sometimes people say walking on eggshell because it's delicate. So you may think of an eggshell. Is eggshell a color? Well, it depends. Most of us, if you go to the grocery store, you're used to seeing usually a white or kind of a cream colored eggs, but they can come in various shades of brown. They can come in blue. If it's a robin's egg, you know, it's going to have a little speckles on it. So can someone describe an eggshell to me? And when you ask different people, you're going to get different answers. And I know you're already thinking about, well, Amy, what in the world does an eggshell have to do with account titling? I'm not making the connection. I found this cartoon sometime back and I really enjoyed it. This isn't exactly what I had in mind when I asked you to paint the walls eggshell. This is exactly what happens when we are dealing with account titling and beneficiaries and other designations. Is what you had in mind versus what you put on paper is not going to give you the result that you had originally anticipated. So in this place, you know, we've got a couple. I had an idea that her idea of eggshell perhaps was just a nice soft color of white or off-white. That's not the result that she got. So let's talk about individual accounts. Those are something that many of us are familiar with. And I have picked this 3-generation family out because it's kind of representative of all of us. Now, if I have John Q. Jones, which is John, he's this good looking fellow in the back, and it has his name on the account as an individual account, then he owns it all. He doesn't share this account with anyone. No one else has rights to the account. It is all strictly John's account at this point. So that one's pretty easy. Well, what about a joint account? Well, in this case, we've got John and his beautiful bride, Jane Jones. So they own all of the amount together. This doesn't mean that John owns half and Jane owns half. It means they own all of it together. And it doesn't really matter. There is no percentage because you either own all of it together or you own none of it together. And in this case, they own it all. So it's very simple when you look at a joint account. It becomes just a little bit different, though, when we add the words on the tail end, which are joint trust with rights of survivorship. Now, we still have John and Jane. But when we add the JTWROS, something changes on the account. This means that whoever the survivor is between John and Jane, that survivor then owns 100% of whatever that account is. So let's think about that. When they were, in our previous example, when we had the couple that is, they own it all together, well, that's only while they're living and they can come and go as they please. But what happens if John dies? Well, does Jane own it all? Probably. But when we add the titling on this of JTWROS, we have assured that in this case, whoever the survivor is, they will indeed own 100% of the account. Now, when we go to the next situation, which is tenants in common, that's a little bit different because we could have, in one example, I've got John and Jane that are tenants in common, but there's nothing that says that we could not have John and his beautiful daughter Tamara here as tenants in common. Maybe these are two different parcels of land. Every family could be a little bit different. Well, in each one of these examples, John owns 50% undivided interest in that property. Now, let's pretend it's a house. Now, you and I both know you can't take a chainsaw and cut it in half and say, well, this half is John's and the other half belongs to the other owner. It doesn't really work like that. But you own a 50% interest in that particular property is one of the examples that we use. And so that property is going to stay with John at his death. But notice tenants in common is very different from joint trust with rights of survivorship, because in tenants in common, now we have the ability to pass this 50% interest on to whoever we want. It may or may not be the owner of the other 50% of the property. That's really going to be the choice of the owner. But what can happen in these situations, perhaps you inherited property and you own this with a sibling. Well, you may own it with a sibling as long as they're alive, but then when they pass with the tenants in common, their estate or their trust, or if they haven't written a will, the jurisdiction they live in is going to determine who your new partners may be. And they may or may not be individuals that you would have chosen if you had the choice. So what is your titling on any type of an inherited or other asset that you have purchased? Because the tenants in common is treated very differently than the joint trust with rights of survivorship that we just talked about. Now, what about et al? This is something I don't see very often, but I still see it on a few really old titles. It's usually on a deed, and in this case, I have put John Q. Jones et al. Now, what that really means is et al is and others, but we can't tell who the others are unless we dig deeper into the titling. And if we're able to dig deeper into the titling, then we'll be able to see who is recorded as the others. Can this get messy? The answer is yes, because if these other owners are deceased, then we need to get into estate issues of where do those shares need to go? Can we even find the heirs? And it becomes a mess in many situations. So whenever I see a John Q. Jones et al., I usually recommend you get on it now versus later, because it's never going to get any better as far as untangling that particular mess. We can have a user. Now, a user could be John Q. Jones with Mary Jones as a user. Now, in this case, our buddy John, you know, the good-looking one, he owns the account and he is financially responsible for the account. Now, he can give Mary permission to use it, but Mary has no responsibilities financially for the account at all because John owns it. He's only allowing her to use it. It will not show up on Mary's credit report, even if John and Mary had an agreement that she was going to use this account and she would pay the balance off. And let's say it's a credit card and she put $10,000 on it. She has no legal obligation to pay that $10,000 off, but John does because it's his credit card and he authorized or allowed her to make those charges. You want to be very carefully who you put on as a user on any account, because you are the one who is financially responsible for it, whether you made the charges or not the user that you authorized to use the account. Now, transfer on death. One of the things that we can do if we'd like to simplify estate settlement and we'd like to avoid probate is to use a handy little title called TOD. And we can put this behind our name. We fill out a piece of paper. It's very simple. In this example, we've got John and Jane that own the entire account. All right, that's pretty easy. And TOD on the account said that when they pass away, the account is transferred to the persons they name in beneficiaries. All right. In this case, let's say that they are going to pass it to their son and daughter, and they're going to give them 50%, but they could do 20/80, they could do 25/75, they could do 99/1, whatever the case may be. But this allows the assets at both of their deaths, because in this case, the account is in both of their names, to pass to their beneficiaries. It does not need to go through probate. It is not subject to creditor claims. They would have to produce the death certificates and identification in order to claim it. But this is a very easy way to transfer assets where you'd like them to go, and there's absolutely no cost. We're going to get into a couple of other terms soon, but at any time, they could go in and change this. If they decided they wanted all of it to go to their son and none to their daughter, all you have to do is change a piece of paper. So it's very, very efficient. That can be done at that point. Now, TOD, so this is something that is very easy, helps with our estate settlement. Well, let's back up just a second here. Now on TOD, transfer on death, we are looking at assets that are not in cash. This could be stock certificates. This could be a mutual fund account. They will not have IRA or 401k account titling. These are all assets that are not specifically retirement accounts. They are accounts, again, that are usually mutual funds, stocks, those type of things. Now we have another one that is POD, which looks similar, but it's called pay on death. And at pay on death, we are looking at cash assets that they can pay. Think about a checking account. This could be a CD. It could be a money market. It could be a savings account, but these are cash assets. And those assets are going to be transferred into your beneficiary's name. Again, we have to show death certificates. We're going to have identification. This will pass outside of the estate. It is not subject to probate. And again, this is simply a piece of paper. If your institution does not offer this, let's pretend that I have $100,000 in my banking institution. And when I ask, they say, oh, well, we just don't do that. It's really up to you to decide if you want to maintain that relationship there, or if it is important enough for you to go to a different facility that does offer this. If it is important to you to keep the money from going into the estate and being subject to creditor's claim, may be worth changing banks for. If it is not important to you, may not matter. If your intent and your desire was to have the money go into the estate and be probated, then that's a choice. I'm going to give you a little incentive not to do that in most cases. I'm going to go back to pretending I have $100,000 in the bank and I have not done any POD. Well, I will tell you that on an average, most estates, for the attorney's expenses in order to handle the details, maybe 5 to 7% of the value of the estate, may vary a little, but that's a good guide. So if I took $100,000 and I did not have POD on my bank accounts and my savings accounts, and I went through the probate process instead, the first thing that's going to happen is my attorney's expense would be 5 to 7%, which could be, $5,000 to $7,000 of shrinkage. Then in addition to that, that money is available for credit cards or any other debts of the estate. Let's pretend that you had $20,000 in outstanding credit card debt. Well, that would have to be paid. Any expenses of the estate, this gives it cash to pay for them. And then whatever is left, if my will had indicated this would go between my children, only at the point absolutely everybody else in line had been paid, would any portion of it eventually end up with my children. So with the pay on death, if I do not want to have excess money into the estate, I could do these POD or TOD. Those would go to my named heirs. There would be absolutely no shrinkage because it did not go through the estate. So one of those really good things to know. And again, I mentioned before that in the description of the class, sometimes these things look like alphabet soup. And these are the types of things that we can do on the tiling of our assets. It's very important that you know what those options are. Now, on the next one we're going to talk about, we got some more initials, FBO, for the benefit of. Now, in this case, Jane Jones, FBO, Lily Jones. And in this case, we're going to make Lily her granddaughter. So you see, Jane is the trustee or the custodian of the account because as we look, we can see that Lily is obviously a minor. She is not an adult yet. Now, Jane is responsible for managing the assets in this account until Lily reaches the age of majority. Now, depending upon the jurisdiction you live in, that could be 18 to 21. It's going to vary a little bit. Now, Jane has no rights to the money in the account. That money belongs to Lily. She is simply a guardian of it. She is responsible perhaps for investing it or managing it, but she has no ownership of the funds. If she was to take this money and spend it on herself, that would be wrong. She probably could be sued. There are options there. So she's merely taking care of this money until Lily is old enough. Now we're going to go back and here's another one, held in trust for. These are accounts I don't see used as often, but they're still out there because they were very popular for many years. UTMA, which stands for Uniform Transfer to Minors Act, or UGMA, Uniform Gifts to Minors Act. Now really the difference between these you'll notice is only one letter. Now, Uniform Transfer to Minors Act, now those are usually stocks or mutual funds. They are not in a cash form. Uniform Gift to Minors Act generally is cash. It would have been perhaps in a CD. It's money that is sitting over at the bank, but it's generally cash. We have similar circumstances to the FBO in that Jane R. Jones, UTMA for Lily Jones. So we know this was a Uniform Transfer to Minors Act. So I'm going to guess that that is a mutual fund or that's a stock account. Once again, Jane is responsible for managing those assets, and she may pick and choose and buy or sell stocks or mutual funds. That may be up to her to manage the account, but she still does not own the account. She's merely the caregiver on that account until Lily is 18 or 21, depending upon the jurisdiction. So let's talk a little bit about a beneficiary. You know, we're talking about account titling, but when many of your accounts, you have beneficiaries that you need to name on them. So the beneficiary is the person that you have named to receive the assets at the time of your death. They have no rights to the assets. They have no right to the information until you've passed away. And once again, we need to produce death certificates and identification in order to claim those assets. Now, in this case, if we look and we see John up in the corner again, he has chosen Mary, his spouse, Jane. I keep calling her Mary today. His spouse, Jane, is his 100% primary beneficiary. Primary means first in line. And he could have named 8 people, any percentages that he wanted as the primary beneficiaries. And then in the event that the primary beneficiary or beneficiaries, if you've named more than one, have passed away, then it would go to the contingent beneficiary. So it's kind of like a backup plan. Now, John's contingent beneficiaries, he happens to have named as his 2 grandchildren, 50-50. Could he name anyone else? Absolutely. Could it be a church? Could it be a charity? Yes, and it doesn't really matter who your primary or contingent beneficiary is. You can name that to be anyone. Generally, the biggest rule of thumb on that is it needs to be a person or an entity like your church, like a nonprofit, like your neighbor down the road, one of your heirs or your family members, and you do round percentages. Such as 33, 33, 34. Usually they will not allow 1/3, 1/3, 1/3 because there are fractions. So usually you're going to use whole numbers that equal 100%. Very easy to do. So now we understand the primary and the contingent beneficiaries. You're going to see these on your retirement accounts, whether they're IRAs, 401ks, simple IRAs, any of those type of things. You're going to see this on life insurance, where you're naming beneficiaries. There can also be annuities with beneficiaries. So not only is the titling of your account important, but who you're naming as beneficiaries is also very, very important. Now, how do we assure that life insurance is tax-free? Because I know many of you just take for granted that this must be tax-free. That's not true. There's something that is called the unholy triangle. The unholy triangle can take tax-free life insurance proceeds and make them taxable. So it's important that when we're dealing with titling and beneficiaries, that we work those pieces together to make sure that you don't take a substantial life insurance benefit and make it taxable to whoever the owner was. The simple part in looking at this illustration, 2 points must be the same. Very easy. And it's especially easy because if you look at the bottom, the insured can never be the beneficiary. On a life insurance contract, if you're the insured and you pass away, well, it's physically impossible to pay the death benefits to the person who just died. So that's one of your first clues on how to fix this. As we look at the 2 points of the triangle that need to be the same, we're going to go through here and let's look at how we can make that happen. Again, our same happy family. So with 2 points that must be the same in our particular triangle, in this case, Jane is the insured. So the death benefit will pay out to the beneficiary at Jane's death. Well, in this case, Jane happens to be the owner of the life insurance policy. At the present time, while this is being filled, generally it's not an issue. The life insurance face amount would be included in Jane's estate. For most families, the estate tax exemption is high enough that's not an issue, but it is something that needs to be considered. Again, talk to your advisors on your particular situation to see who might be the best owner of the coverage. But we've got Jane as the owner and Jane as the assured, and we have John as the beneficiary. Now, because these 2 points of the triangle are the same and John is the beneficiary, that life insurance is going to pass to John tax-free regardless of the amount. Very easy. Now, what if we change it just a little bit? We still have Jane as the insured. When Jane passes away, the life insurance benefit will be paid to the beneficiary, who is John. Now, you will notice in this case, John is the owner of the life insurance policy. Perhaps we did this for estate planning. What that does is at Jane's death, because John owns the policy, the amount of the life insurance policy would not be included as part of the assets in Jane's estate because she did not own the asset, John did. When we are doing these types of estate planning cases, John would also name a contingent owner. Most of the policies are written, so in the event that the owner, which in this case we've made John, passed away before the insured, then the ownership would revert back to the insured, which would be Jane. And for estate planning purposes, we may not want that to happen. When we have an owner that is other than the insured, then I recommend that we already put a contingent owner on the policy, and that could be one of their children or both of their children. Whoever the owner of the policy is, that gives them the right to change who the beneficiary is. Again, we have a lot of ways that we can use our assets to accomplish what we want. But we need to be very conscious of what our titling beneficiaries and how those work together to get the results that you want. Now, on the unholy triangle that I mentioned that makes those benefits taxable, well, all 3 points are different, so we want to avoid this. Now, how did we make this taxable? Well, in this case, if I said, well, John is the insured, that's pretty easy. When John passes away, the death benefits are going to be paid to the beneficiary, who in this case has been named as the grandchildren. So we now have 2 different points on the triangle. Now, the third point on the triangle, you'll notice Jane is the owner. but Jane is not the beneficiary. What happens here is that at the end of the year, for tax purposes, Jane is probably going to get a 1099 or a similar form that will indicate that she took and she made a gift of the life insurance proceeds to her grandchildren. Now, I want you to back up on this a little bit, and we have triggered a gift tax, which probably was not the intention, because the grandchildren were the beneficiaries. They received all of the life insurance proceeds. Jane did not get a dime. However, Jane, in gifting the life insurance to the children, is responsible for paying gift taxes, and a gift tax return has to be filed. What if this was a $500,000 or $1 million policy? How much is the gift tax? Well, that's a great question. It depends on the circumstances of how much more. Did she give the children $25,000 gifts this year when John died? What are the circumstances? But it's going to cost Jane a significant amount of money in gift taxes because she gave the beneficiary to the grandchildren and the proceeds, even though she didn't receive a dime. My guess was not the intention. There is another method that could be used in working with your tax professional, that Jane could claim this against her estate as part of an estate tax exemption, but we could have easily avoided this situation just by handling the titling or the ownership a little bit differently. So now you've learned about the unholy triangle. Got one little thing that came in earlier on this one because I've went over this before. When you have an unholy triangle, how do you fix it? Well, talk to your agent. You may need to talk to a tax professional. Some cases you may need to sell the policy to the individual. Maybe you sell it, if it's a term policy and there's no cash value, maybe you sell the policy to change the ownership for a nominal sum, $100, just to make the process work. If it is a policy that has substantial cash values and we want to change the ownership, then there are a couple of mechanisms. Maybe you write them a check for the cash value in the policy, or you borrow the money out to make it worthless, but there are mechanisms that we can use. It depends upon the type of the policy, whether it is a permanent policy, that could be a whole life, it could be a universal life, it could be a variable universal life, it could be an index life insurance contract, or if it is a term contract. But if you work with professionals, they can certainly look at your dynamics and help guide you on what is going to be the best thing for you to do at that point. Now let's talk a little bit about what you can put behind the names of your beneficiaries to even take it a step further to make sure that your wishes are carried out. The term per capita, and some of you have these terms. We're going to talk about per capita and per stirpes that are already in your will, living trust documents, and some of those, and you have no idea they're there, and you had no clue what they meant when you signed the papers. You should pull them out and you should look at them. I recommend that you put these behind every beneficiary: life insurance, your annuities, your estate documents. You need to understand what they mean in order for you to distribute your assets the way that you intended. Now, per capita means it's only divided between the named living beneficiaries. So per capita, each. Now, if I take it just a little bit further, and I go to per stirpes, I'm pretty sure that's a word you don't use very often. Per stirpes is divided between the named beneficiaries, if they are living. If they are deceased, they are still a beneficiary, but then that would pass to their children. This is often used because grandparents will not want to disinherit grandchildren because their parents died. So it's a mechanism. Do we have to do it? The answer is no, but we have the option to do it. Now, what if I named my son per stirpes, but he didn't have any children? So the per stirpes was pretty useless. But I didn't want to change my beneficiaries all the time, so I just put it that way, anticipating he was going to have children at some point. well, then his share would revert back and would be divided between the living beneficiaries. But we always have, what is our intent? What is the ripple effect? And then what will happen at that point? So very easy to control what happens with our assets if we want to. Now let's talk about how account titles impact your estate and your credit report. Now, when an owner dies and leaves assets to heirs, it depends upon what the titling of the asset is on how much, if any, of those proceeds will be taxable income to the beneficiary or the recipient. Now, many of you are the proud owners of IRAs, 401ks, 403bs, 457, simple IRAs, SEP IRAs. There's a whole variety of accounts that are tax deferred that are related to retirement. Now, it doesn't matter on those types of assets where you have deferred the tax, and that meant that you got a tax deduction at the time that you put the money in, but you were going to pay the tax later. Whether you spend the money or your heirs spend the money, whoever is the person who spends it is the person who will pay the tax. Well, how much is the tax? I don't know. Think about that this is going to be the last money that comes in. If my daughter inherited my IRA, and on that IRA, she has already got a job, she's already making money, whatever, and they decide to take $50,000 out of the IRA to put down on buying a car or a house. That $50,000 would go into her income, but in many ways, it's the last dollars coming in the door. She would need to talk to a tax professional to find out what tax bracket would apply for that $50,000. And that could bump her into a higher tax bracket. Maybe she jumps from 22 to 32%. That's something that we don't know for sure. Now, with that, we're also going to look at the accounts that are after-tax accounts. Now, these after-tax accounts are going to be your Roth IRAs or a Roth 401k. You did not get any tax advantage at the present time in order to, fund these accounts. But as long as you follow a few simple rules, then all of the proceeds on these accounts are going to be tax-free to whoever spends them. Now, if you are the owner of the account, when you have anything that says Roth on the title, if you have this account and you do not take the funds out for at least 5 years, and you are over the age of 59 and a half, then all of the proceeds are going to be tax-free to you. There are some caveats that if you needed to take that money out earlier, that you can pull back out your contributions without taxation, but we're not going to cover that here. That's a conversation you need to have with your tax professionals before you ever take anything out. Now, in addition, on the Roth accounts, at my death, if I owned a Roth account, whoever received the money would be able to spend that money tax-free, and it would not show up on the tax return, because it was always tax-free. And even if my beneficiary was under the age of 59 and a half, they would still be able to take that money out tax-free because they were a beneficiary, and the age 59 and a half and 5-year rule do not apply. Whether you are the owner of these accounts or you are potentially the beneficiary of the accounts, you want to talk to your tax professionals before you fill out the paperwork to claim it, before you decide to cash it, to know exactly what your tax liability may or may not be. Now, there's one other asset that I see commonly, and it's called a tax-deferred annuity. This is not the same as your retirement annuity that you may have through an employer or through TIAA-CREF. This is something that you would take money and you would put it into an annuity that is sold by an insurance company. The money that you put in is already been taxed, but all of the growth or the earnings on your annuity, that's called non-qualified, will be taxable at the time that it is removed from the account. And whether it is the person who funded the annuity or it ends up being the beneficiary, that person will be the one that will pay taxes on the growth in the annuity. Now, we also have what's called a survivorship pension. Now, a survivorship pension is taxable to the person who spends the money. If I had a pension and I had a survivorship, and let's just say hypothetically, I get $1,000 a month in the pension, and I signed the form so that at my death, my spouse continues to get $1,000. So if I died before my spouse, they will continue to get my $1,000 pension for their lifetime. Well, it doesn't matter whether I receive the money or my spouse receives it as a spousal or a survivorship pension. That person will pay the money because a pension is always taxable. It doesn't matter who gets it. Now, rarely do I see the option for you to name a beneficiary that is not your spouse. That could be for a survivorship option. But I have had a few of those, and for estate planning reasons, we ended up naming adult children as the survivorship pension recipient with the idea they would collect it for more years and it would have more value. Is it unique to your pension? The answer is yes. Do you need to talk to an advisor before you make those decisions? I would highly recommend that. Now, life insurance, if not structured correctly, we've already revisited just a few minutes ago about the unholy triangle. So if we structure it correctly, it doesn't matter whether the life insurance is $1 or $150 million. Life insurance, when structured correctly, will continue to be non-taxable or tax-free to the beneficiaries. Dorothy, saw you. Glad you joined us. Now, when the owner dies and leaves assets to heirs, again, we talked about life insurance is non-taxable to the beneficiaries. But that kind of leads us into a couple of other conversations. When should you use an irrevocable life insurance trust? Maybe you do not want the insurance assets to be owned by you personally because you don't want it included in your estate when they're counting up the assets. Maybe you don't want to hassle with having someone else own the policy and contingent owners, and you don't even want to think about that or somebody messing it up. An irrevocable life insurance trust could be the owner and the beneficiary of the life insurance contract, and that trust may do a specific thing. Maybe you have it set up so that it would pay out a certain amount to the beneficiaries over a period of years, and then it's dissolved in the 25th year. Maybe it is designed to continue gifts to charity in addition to that. I don't know. It would be your trust, but the key words are irrevocable. Once you have set this up, you cannot change your mind. So it is really pretty much set in stone. It definitely has a purpose and a place, but it's something you need to talk to your advisors about to make sure you're getting exactly what you want. The question has come up before of, well, if I do an irrevocable life insurance trust and I decide that we don't want the life insurance policy in it anymore, can I get it out? The answer is yes. The irrevocable life insurance trust may come up with an agreement to sell the policy to someone to be able to change the ownership to get it out of the trust, but then the proceeds have to stay within the irrevocable life insurance trust. There are options. Do you need to speak to a professional? The answer is yes. And it always goes back to, well, who should own the policy? Well, in some cases, if you are a business owner, for specific reasons, we have the business own the policy and the business is the beneficiary. Sometimes the spouse will own it, sometimes the children. What if I have a business partner? There are cases where I need my business partner. What if I borrowed money to buy my home from my dad? Maybe my dad owns a life insurance policy on me, and in the event I die before I've paid off the house, my dad has the life insurance proceeds to pay off that balance, and he doesn't need to fight with my spouse and the kids through an estate to try to collect the mortgage money that he really needs and can't afford to give the family. So lots of different options that you have on ownership of the policy, which brings me to another point. For many of you, you need more than one life insurance policy because of ownership issues. Maybe in my business, I need one that my partner owns to buy me out. Maybe I need one that is owned by an irrevocable life insurance trust for a specific asset protection program. Maybe I need one that my husband has owned that is on me, because they're doing different things with different beneficiaries. And I often find it very difficult to make one policy do everything when I have that many different dynamics going on. You can have more than one that do different things. They could be some term policies, they could be some permanent, it could be some magic mixture. Your household is unique. I get the question, how much life insurance is enough? Well, there's two quick methods I use. I call one the wish method. The wish method comes about because I take a piece of paper or type it on the computer or in my notes on my phone, whatever works for you. And I write down what I wish the check was big enough to do. Well, I wish it would pay, up to $25,000 to settle my estate. I wish it would pay off the house. I wish it would put $50,000 each in college funds for the kids. I wish it would leave $100,000 to charity. Whatever the case may be, your wish list is you're just determining how much you wish the check would be in order to do everything that you wanted it to do. Is it a perfect method? No. Is it a good method? Yes. Is it the right method for you? I don't know. That's usually something that you kind of have to balance. Then the other method that I use, it is very simple to use, is at least 20 times earnings. Let me give you an example. And I use round numbers because they're so easy. Let's pretend a person makes $50,000 a year. Well, 50 times 20 is $1 million. And some individuals that would say you need $1 million of life insurance say, oh my gosh, that's way too much. And no, it's not. If I took that $1 million of proceeds and I was your spouse and I had kids to raise, if I invested that $1 million and I averaged 5%, now it's a number. Some are going to get more, some are going to get less. But $1 million with a 5% earnings is $50,000 a year. All I have done is replaced the current income. Now, over time, you're going to have cost of living raises. Things are going to change. So they're going to reach a point within a few years. They may be starting to dip into principal, but we need this money to last for many, many years. That's the intent of it. I will go up to 30 times on the income method if we have disabled family members who we are taking away a primary caregiver. We're going to have to pay for much more staffing or other things that make the replacement of the wages a part of the equation, but then the additional dollars that are going to be needed to do the caregiving also have to be included. And most insurance companies, when you can show a reasoning as to why we want to go up to 30 times earnings with those type of situations, will allow that amount because those are circumstances that are unique to that individual. Again, talk with your professionals, with your family dynamics. It can make a huge difference. Well, how much taxes do heirs pay on taxable inheritances? Well, again, we mentioned this before. It really depends on what tax bracket they're in. And it can change widely. I mentioned, in one situation here, if a person was to take a $50,000 withdrawal out, that could be a very different tax liability than if they decided to go hog wild and cash out a $300,000 taxable account. The $300,000 taxable account may bump them up into a 40% tax bracket. Ouch. In addition to that, if they have state income taxes, that could add another 3 to 10%. It may be stupid financially. There's no other word for it, but stupid to go ahead and to spend or lose 40 or 50 cents on the dollar because you were in a big hurry to spend the money instead of maybe systematically taking it out or having a little bit better plan. Do you own digital assets? Many of you do. There's cryptocurrency. You've got Facebook pages, Pinterest accounts, Twitters, websites, domain names. I mean, it's all out there. Now, when you own digital assets, this is an entirely different category. Most of you, if you have older wills, you didn't even address any of these types of issues. If you have these assets, most of the vendors or the owners, like Facebook, like Pinterest, already have rules about what happens to these accounts when you die. We all know some individuals who have Facebook accounts that have passed away, that those Facebook accounts will live forever. Some families want that. Some families don't. But there are, you can reach out to the organizations. There are forms, papers, and things that you can fill out where you can designate someone else to take over those accounts at your death and to manage them. But that person would have the ability to remove the account or to allow it to remain into perpetuity. So you want to choose this person wisely, but these are assets that you don't always think about on the titling of your assets and what the eventual disposition of those assets may need to be. Now it's time to check your understanding of what we've learned so far. So we're going to do a couple of really quick, true or false quizzes. And these are things that, you can unmute and you can shout out the answer if you'd like. You can type it over in the text box, but we're going to see what you picked up off of the presentation. So here we go. Let me look over here, and before I go into those, I'm going to look and see if there are any other questions that have come in at this point. No. Hello, Lee. It's nice to see you here. I'm going to go through just a couple of true-false questions, and then I'm going to open it up for live questions because this is a real small group today on where we're at. So let me finish this little bit, and then we'll come back. So true or false? You can have a joint trust with rights of survivorship account with transfer on death titling. Anybody want to shout out an answer, true or false, between you two? Going once? Going twice? The answer is yes, because if I have a joint trust with rights of survivorship account, I am assuring that the survivor can have the benefits, but when the survivor dies with transfer on death, then they are assuring that at their death, that account is going to pass and it is not going to be part of probate proceedings. It's not going to have attorney fees. It's not going to be shrunk by any estate expenses. Excuse me, may look like a busy title, but did I accomplish exactly what I wanted? The answer is yes. Now, a user will have account information reported to the credit bureau. A user. We went over this before. Anybody going to jump out, or are you guys going to be really quiet today? Okay, well, the answer is false, because a user has absolutely no financial responsibility for the account. The account owner has the financial responsibility, so it will show up on their credit report. Another one, I can by will dispose of my tenants in common interest in the house I own with my son. Well, absolutely, because as tenants in common, you own a 50% undivided interest in this property with your son. You may give it to your son, you may not. You may decide to give it to your neighbor down the road, and you would determine who the new partner in this property is with your son. Another one, I can only by revocable living trust dispose of my tenants in common interest in the house I own with my son. I can only by revocable living trust. Well, this is false, because we just saw that we could do that by will. You may do it through a revocable living trust, but it is not the only method that you could use. Now, remember, I could also sell my 50% interest in my tenants in common, and I do not have to have permission from my son to do that. So the titling is very, very important. Diana was a user on her mother's credit card when she died. Diana will be allowed to continue to use her mother's credit card line with no issues. What do you think? She's been doing this for 10 years. Well, the answer is false. Diana was a user. She never owned the account. And of course, as soon as the credit card company is notified of her mother's death, that account will be shut down. It will become part of the estate liabilities, but Diana will need to do something on her own. I'm single. My survivorship pension will be tax-free if I give it to my minor age grandchildren, as long as I do not have a spouse at my death. What do you think on that one? They're minor age grandchildren, so should they get it free and not have to pay taxes? Because, you know, kids usually don't pay taxes. The answer is false. It doesn't matter whether you're married or not, or who you give your survivorship pension to. Pensions are always taxable. Has nothing to do with the age, the name, or the family relationship on those. When my adult son is named as POD, or pay on death, he can stop by the bank and find out how much is in the checking account or call them to ask about my balance anytime. What do you think? Pay on death. Absolutely false. If it is a really good bank clerk, they will smile when they say, POD, do you have a death certificate and do you have your identification? Because until you can produce those two particular documents, I can't even tell you if that account is here or whether there's any money in it. So POD still protects your privacy on the account, does not allow the beneficiary to access it until they produce the death certificates and then also the identification. Now, early on in this presentation, I had used this little cartoon when we talked about, this isn't exactly what I had in mind when I asked you to paint the walls eggshell. Well, we know from what we've learned today on the titling of our assets and how we list our beneficiaries has a significant impact on whether these actually accomplish what we intended or if it backfires and it becomes a mess. All right. Well, thank you so much for joining us today. Have a blessed and wonderful day, and we'll see you soon.